This is Linda Hildreth with the Iowa Department on Aging, and I'm just going to go over a couple of little housekeeping things, and then we'll get the presentation started. We're really excited to have Kim Murphy from the Department on Aging and Chantel Smith from the Attorney General's office, and then Margaret Van Houten from Davis Law Firm. They all have been very instrumental in helping get different legislation passed and crafted to help with elder abuse, neglect, and exploitation. So these are all kind of safeguards to help protect older Iowans and also vulnerable adults. So it'll be interesting to hear what has happened and their presentations, and meaning the PowerPoint presentations that you will see today, as well as a recording of this presentation. If everything goes right with technology, keep your fingers crossed, will be saved and put on our website after July 7th. So you'll be able to download the presentations and also the recording. So if there's some people that weren't able to make it today for whatever reason, they'll be able to hear it then and also to receive all of the information. Speaking of technical difficulties, we have been having a couple of technical difficulties on our end and have been trying to work through them the last couple days. We believe that we have it all fixed, but if we do not, if we lose connection on this end, please do not hang up. We will get reconnected onto the webinar. So again, if you lose connectivity here and you can't hear anything, it's probably on our end, and just stay hooked up to the webinar and we will join back in. So your computer screen, there should be a menu, and there's a tab that says questions. If you would please type in any questions that you have throughout the webinar. We do have someone here that is going through the questions, and if time allows, we're hoping to do questions after each speaker. Depending on how the session goes, if we need to wait till the end, we built in a half hour at the end because we figured there would be lots of questions, and we want to make sure that we can get as many of them answered as possible. So make sure that you register your questions. For the quality of purposes for audio, we have everybody muted except for the speakers, and that way everybody can hear and there won't be some white noise, the background noise that comes in that might distract people. So again, register your questions, and if questions are not answered during the session, if we have so many that we can't get a hold of them, please don't worry, we will get your question answered. There is a report that is generated after each webinar, and it connects your name and your email address and your question with you. So what we'll do at the end, if there's any questions that are not answered, we'll go through that report, and we will send the questions to the applicable presenter, and they will get back to you via email. So with that said, I'm going to turn the presentation over to Kimberly Murphy, and she's going to talk about the overview of elder abuse legislation that occurred in 2014. Kim?
Good morning. Thank you, Linda. I am the Policy Director at the Iowa Department on Aging, and what that means is I get the opportunity to work with the passage of legislation and voicing concerns on legislation that impact older Iowans. So I'm going to talk to you a little bit about elder abuse legislation from my perspective over under the Golden Dome. We're going to talk about three basic topics today. The first one is barriers to passing elder abuse laws. For those of you who have worked with elder abuse for many years, you know it's been a bit of a rocky road, and so we're going to explore why that is. We're going to talk about the Elder Abuse Task Force that has met for the last 2 years. The Elder Abuse Task Force was instrumental in many of the pieces of legislation that spun out of this past session, so we'll talk briefly about that. And then finally, I'm going to discuss bills that were presented last session. You see in the PowerPoint it references last session, and this means the most recent session of the General Assembly that ended in May. So I will go ahead and begin with barriers. You may be wondering, why am I starting with barriers? Am I negative? Am I a glass half full kind of gal? From my perspective, we really can't get where we need to go with elder abuse until we understand the historical context. Why has it been difficult? What are the thought processes behind legislators and advocates? All these things have a tremendous impact on our success in passing elder abuse legislation. So that's really where we're going to start. We start in a really good position, and that is everybody generally agrees that elder abuse is a bad thing. Democrats, Republicans, the general public, advocates, everybody says on the surface of it, elder abuse is bad. You're not going to find anyone who says, you know, I think there are some benefits there, let's really discuss it. No, we know it's bad. We know it needs to stop. So it really starts out in a great position from a legislative perspective. Not all legislation gets this good of a starting position, and I'm going to use the dove hunting example. Some of you may recall there was many years a debate on whether dove hunting should be allowed in Iowa, and the legislation did finally pass a few years ago. But people were really polarized on whether doves should be hunted. There were people who really felt they should be, and there were people that really felt they should be protected, and there wasn't a lot of ground in between. Well, like I said, with elder abuse, everybody believes it's bad. So what happens to elder abuse as it goes through the legislative process that causes it to fall apart? So I'm going to start with barrier number one. It's really complicated. Elder abuse is different from dove hunting based on these complications. Take, for example, population that is covered by an elder abuse law. It should be pretty basic. Who is it that we're covering with this law? But we have 50 different states and 50 ways of addressing the population that's covered by elder abuse legislation. You have some states that refer to an individual who's incapacitated and varying degrees of incapacitation. You have some states that use the term vulnerable. What does that mean? Endangered, impaired, dependent, at risk, elderly, infirm, disabled, protected, older individual. These are all different ways that different states are describing the base population that should be covered by elder abuse laws. So it's really complicated. Other ways that it's complicated are even just looking at the basic forms of elder abuse. You have physical, mental, sexual, financial exploitation, neglect, abandonment, self-neglect. And within each of these categories, you have all different ways to describe and define the abuse forms. So it becomes very difficult. Then to make matters worse, you have qualifiers. You may have an abuse form, but there have to be certain qualifications that are met for that abuse form: undue influence, coercion, fiduciary roles, caretaker roles. So as you can see, the issue gets complicated very quickly. So we're going on to barrier number two, and that is definitions. If you want to see something interesting, put a group of lobbyists in a room with a list of definitions. And as lobbyists, we're going to argue vehemently and for a very long time over definitions. Why is that? It's because definitions are the cornerstone of any good piece of legislation. They're absolutely crucial, and elder abuse is no exception. We have to understand the definitions that are being used for elder abuse before we can craft any good legislation. And like we talked about in the barrier for complication, there are a lot of definitions. And for those of you who might work with legislation, you know that definitions make people crazy. Trying to figure out how you're going to define your population, how you're going to define those forms of abuse, how you're going to define those qualifiers, it gets very difficult. And then to make matters worse, in the context of elder abuse, the definition may be used in a different way depending on the context. If you're looking at a criminal law, a civil law, an administrative law, the definitions may be used differently in each of those contexts. So definitions have to be very precise, and it becomes very difficult when working through some of those elder abuse definitions. The third barrier is in regards to elder abuse is you have multiple systems and agencies that are all involved and all have a piece of elder abuse. You see the Department of Human Services has the Dependent Adult Abuse System. Department on Aging has elder abuse pursuant to the Older Americans Act. Department of Public Health has training for dependent adult abuse. Inspections and Appeals handles elder abuse in facilities. The Attorney General's Office looks at elder abuse in the context of a crime. And this is just at the state level. There are other agencies at the local levels that also deal with elder abuse in their own ways. So it becomes very difficult when you have so many systems and agencies that are involved. In addition, you also have different laws, different pieces of legislation, multiple statutes that play into elder abuse. So it all becomes very complicated when you have numerous players that have different pieces of this system. And how do you find a solution? How do you navigate that? This had an impact during the past legislative session. We were trying to figure out, as advocates throughout the legislative process, who is it that's going to operate this elder abuse system? Who's going to have the primary responsibility? If we collaborate, how does collaboration occur? What statute do we draw from? Is there a statute that we should be utilizing entirely? Are there pieces we take from statutes? So this became an issue of complication during the past legislative session, and no doubt will impact how legislation rolls out moving forward. The fourth barrier, of course, with any system that's going to be implemented is how do you pay for the system? And again, this did have an impact this session. It became a key issue. There was a need to whittle down to a budget amount that was something that both the House and the Senate could live with. And this is really what drove the result of Senate File 2239. And Chantel Smith from the Attorney General's office is here, and she'll talk to you a little bit about what that end result was in Senate File 2239. But no doubt money is always going to impact legislation, and what the cost of a system is will always be a factor that has to be considered. So we talked about those barriers. What happens when you have all these barriers, all these complications? Remember, we talked about elder abuse starting out in a great legislative position, everybody agreeing. The barriers start to erode the starting position, and you start to see fractures develop among advocates. I'm going to give you an example of what I mean by a fracture developing. We're going to take a really basic definition of financial exploitation. And when I say it's very basic, I mean it is. It's oversimplified, but I think it gives a good illustration. So if you look at the example of financial exploitation we have here, it's a process by which an individual knowingly takes, retains, or disposes of the funds, property, or resources of the target population that result in depriving the target population of resources. Seems pretty basic, right? Well, let's look at the different multiple interests. I have a few examples here of multiple interests and ways people are looking at this definition and deciding what position they're going to take on it. So let's start with the example of a widget salesman, someone who goes door to door and sells widgets. The widget salesman is going to look at the definition of financial exploitation and say, you know, I really do take funds from somebody to deprive them of resources. I'm selling them widgets. Now, yesterday, I went to Edith's house, and Edith is in her 80s, and you know she's not so good at balancing her checkbook anymore, and I sold her 200 widgets, and she might need just one. I could be taking advantage of Edith just a little bit, and I'm kind of worried about how this financial exploitation definition may influence me, may have an impact on my ability to sell in a free enterprise market. I think I'm going to fight this bill. Okay, so then you maybe go to families who are farming. And they look at this bill and they say, you know what, the farm that we have has been in our family for 3 generations. If as a son I want to retain the farm from my dad without paying market value, I want to just keep it in the family, I sort of meet this definition of financial exploitation. You know, I'm not so sure about this. I may have some concerns. I think it needs to be tweaked a little bit to make sure that when we want to pass this farm on, we're not prohibited by this definition. This needs to be worked on. Then maybe you have prosecutors who are looking at this definition, and I'm not a prosecutor, so I'm just guessing that maybe they say, you know what, this is nice, this is broad, there's nothing too difficult to prove. We really like this definition. We don't want it changed. We want to keep it just the way it is. So you can see where these fractures start to develop when you're looking at the elder abuse systems. So what happens when you start to get a lot of fracture? Like in a situation with elder abuse, you could have multiple entities, multiple organizations, multiple agencies all weighing in different ways, and you start to see the splintering of ideas and concepts. The legislative response to fracture is to sort of kick the can down the road and move it to someone else's responsibility zone. Because, right, you're a legislator sitting there. Every day you're having multiple people coming to you. Every day they're saying, we like it, we don't like it, here's why. You're getting all kinds of feedback, and none of it is consistent. It's very confusing. You can't make heads or tails of all of it. You can't find a compromise. So you shift the responsibility to the experts who may know more about this and say, you know what, why don't you experts, why don't you get together and why don't you tell the legislature what it is we should do in response to elder abuse situations in Iowa. And that's exactly what happened here in Iowa. There was a task force convened in 2012, a task force convened in 2013, and in regards to the 2013 task force, there was an interim committee, which means a group of legislators who were assigned to particularly look at that issue and make recommendations outside of the scope of the legislative session. So the first task force was convened in 2012. And I'm going to talk to you about those task force recommendations. But first of all, I just want to let you know who was on the task force in 2013, because the players on the task force in 2013 and 2012 were pretty similar. So I'm just going to read off the task force members. AARP, Alzheimer's Association, the Area Agencies on Aging, Attorney General's Office, the Commission on Aging, we had a consumer representative, the Department of Human Services, the Department of Inspections and Appeals, the Department of Public Health, the Department of Public Safety, the Department of Veterans Affairs, the Department on Aging, the Insurance Division Securities Bureau, Iowa Bankers Association, Iowa State Bar Association. There's a representative from the Iowa Judicial Branch, Iowa Division of Banking, Iowa Healthcare Association, Leading Age Iowa, Long-Term Care Ombudsman's Office, Department of Human Services, Division of Mental Health and Disability Services, National Health Law and Policy Resource Center at the University of Iowa, the Older Iowans Legislature, the Polk County Attorney's Office, and the University of Iowa School of Social Work. So can you imagine, this was a big task force. There were a lot of people who have been working with elder abuse for a very long time weighing in on these issues. So what were the task force recommendations that spun out in 2012? And remember that these recommendations did have an impact on the past legislative session and what came out of it. So here are the recommendations in 2012. We need an elder abuse definition and law. We need safeguards from financial exploitation, and that includes financial power of attorney documents. We need an elder abuse intervention system. We need money. We need to fund this somehow. We need specialized education and training for those that are dealing with elder abuse. We need to strengthen fiduciary laws. We need multidisciplinary teams, a single entry point. Oh, sorry, I'm going on to the next slide here. We need to strengthen fiduciary laws. We need multidisciplinary teams. We need a single entry point, so one place where people who have elder abuse concerns can go versus like we have a fragmented system right now, different intakes depending on where the abuse is occurring and what type. We need safe havens, the places where people can go to be safe if they've been subject to abuse. And we need to collaborate. We have so many groups working on this issue. We need ongoing collaboration. So that was the 2012 recommendations. Here come the 2013 recommendations. I'm assuming these will look familiar. We need an elder abuse definition and a law, safeguards from financial exploitation, specialized education and training, strengthen fiduciary laws, and a single entry point. So it's the same recommendations, but maybe just a little bit more precise, a little more honed in. So knowing that there was a task force that met in 2012 and 2013, I'm going to give you a really quick overview of the legislation that spun out of the task forces that came through last session. I'm not going to cover them in detail specifically because the next two speakers are going to dive a little bit deeper on two of the pieces of legislation. So I'm just going to give a brief overview of the legislation. So there are four things that spun out of task force recommendations that were passed last session. The Iowa Uniform Power of Attorney Act. There was legislation to reinstate the Office of Substitute Decision Maker. There's some funding for an elder abuse system. And there is a piece of elder abuse legislation known as Senate File 2239. So those are the four main pieces of legislation that spun out. This is a tremendous first step forward considering all the ups and downs that elder abuse legislation has seen over the years. The first one is the Iowa Uniform Power of Attorney Act, and we do have Margaret Van Houten who will be speaking today, and she'll go over this in detail. But basically, this is an adoption of the Uniform Power of Attorney Act with a few Iowa modifications, and I'm sure she'll talk to you about those. But I did just want to say I have a few favorite things within the Iowa Uniform Power of Attorney Act, and those are very clear duties for agent action, suspension of a power of attorney if a conservator is appointed, the ability to seek judicial relief, the ability to take this document to court and get some assistance, Durability is presumed, and there's a form that's included that can be used for that. So those are just a few things that I think are really great about it. The next thing that you'll see is that the Office of Substitute Decision Maker is going to be reinstated. This was a program that existed from 2007 to 2009, and it's basically a public guardianship program, although it is a bit broader because the office is meant to address services, supports, and public information regarding guardianships, conservatorships, power of attorney documents, representative payees, and personal representatives for estates. When it existed from 2007 to 2009, the office was able to do motions to intervene in guardianship and conservatorship cases where an individual was behaving inappropriately as a guardian or conservator and contrary to fiduciary duty. So basically there was $288,666 that were provided for the reestablishment of the office. And so the Department on Aging will now begin to lay the groundwork to bring that office back to life. The next piece of legislation that will impact elder abuse is House File 2463, which is the Health and Human Services Budget Bill. And the Health and Human Services Budget Bill appropriates funding for initiatives and programs within Human Services executive branch agencies. So the Department on Aging, the Department of Human Services, the Department of Public Health, and Veterans. What this bill did is it gave $525,000 to be distributed to the area agencies on aging to administer the Prevention of Elder Abuse, Neglect, and Exploitation program pursuant to Iowa Code and the Older Americans Act. We're still working out the specifics of precisely how this will work, but we know it will be modeled on the Elder Abuse Initiative pilot projects that existed from 2001 to 2011. So that will be the basis of those. Finally, there was what I'm calling elder abuse legislation, or Senate File 2239. I like to think of this as the Forrest Gump bill. I don't know if any of you have seen the movie. I'm sure most of you have, but at the end, the theme song for Forrest Gump plays, and a little feather kind of floats through the air and bounces around, and then a breeze comes and picks it back up, and it moves along. And I like to think of Senate File 2239 as that little feather. It would sort of float, 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 and then it would settle, and all of a sudden there'd be a big breeze, and it'd pick back up again and move, and then it would settle down. And it just kind of continued to float back and forth between the House and the Senate. It was also a little bit like a Forrest Gump bill because many of us who were working on it felt like it indeed was a box of chocolates, and we weren't sure what we were going to get at the end of the day. We just weren't sure what it was going to look like. And I'm not going to give you the specifics of it because I believe Chantel Smith will be discussing it in detail. But I do just want to illustrate some of the bouncing that occurred. So on March 4th, it passed the Senate, and that took a lot of work to even get it to that point. It passed without objection in the Senate, and I think it went through subcommittee and full committee with not a lot of objection. I think everyone was feeling kind of good. It's moving forward. It goes over to the House, and then it sat in the House for a while, and I think everyone was kind of nervous what's going to happen. It made funnel, just barely, but there's all of a sudden a lot of comment going on in the subcommittee and the full committee. So it passes the House on March 25th. It bounces back over to the Senate, and again it sits for a while. Everyone's thinking, what's going to happen, what's going to happen? The breeze blows up again. The Senate amends it and sends it back to the House. It goes back to the House, and it sits in the House and sits in the House, and we thought, oh, perhaps this is it. Maybe this is the death of the bill. Well, then the House refuses to concur, and they send it back to the Senate. The Senate takes a look at it. The Senate says, no, 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 we insist. It goes to the conference committee, and then what happens? What does it look like? And that is where I turn it over to Chantel Smith from the Attorney General's office, who will tell you what it looked like at the end of the day.
Hi, thank you, everybody. I am going to pick up just where Kim left off. Great transition by her, of course. All right, so Senate File 2239, or as Kim called it, the Forrest Gump bill. I'm just calling it generally elder abuse relief, which there's just not a good way of describing this bill, so that's what we're going to say. Just generally, who are the players in this?
Kim is talking about it bouncing back and forth and advocates here and there. As far as the government goes, you've got DHS, Human Services, DIA, Inspections and Appeals, you've got Aging, you've got the AAAs in there, the Attorney General, the county attorneys, law enforcement, and folks like you, advocates, people with an interest who are in there pushing for this or pushing for some form of it. Where did we start? As Kim referenced, we have the Older Americans Act. That's the federal law that places a mandate on the Department on Aging to, well, essentially to push laws like this to create and maintain programs addressing and dealing with elder abuse. That's at the federal level. At the state level, we have Chapter 235B of the Code, which many of you are probably familiar with. That's the Dependent Adult Abuse chapter administered by Human Services, DHS. It covers dependent adults, that's 18 or older, so not focused on the elders in the state, but includes older Iowans. It has the caretaker requirement, requires specific allegations of abuse per Chapter 235B. The determinations of abuse are made by DHS, and protective services are implemented by DHS. Referrals are made to the county attorneys for criminal prosecution of abusers. Then we have Chapter 235E, which is Dependent Adult Abuse in Facilities and Programs. That's administered by Inspections and Appeals, DIA, so we get another agency involved. That too covers dependent adults, not just older Iowans. Caretaker requirement, that's employees of facilities. Again, you have to have a specific allegation of abuse per 235E. This time DIA makes the determination of abuse, but DHS implements the protective services, and the county attorneys again come in on the criminal side. So that's where we start. For years we've been trying to tell people we don't have an elder abuse law. This is what we have. We need the elder abuse law. So we get Senate File 2239, the Elder Abuse Bouncing Bill. Where did that start? Where were its roots? In the Elder Abuse Initiative, which many of you are familiar with, which Kim referred to earlier, running from 2001 to 2011. In this initiative, went through the AAAs, clocked referrals. What did they see? 11,903 referrals, and that in the 5-year period, basically. More interestingly, what did they find? 44.4% experienced financial exploitation, telling us that physical abuse, physical, sexual, the types of abuse that maybe are more in people's minds, isn't the only kind of abuse going on. We've got financial exploitation, and we need to address it. What did the Elder Abuse Initiative come out with? Kim referred to this earlier. Basically 4 recommendations. We need a definition of elder abuse. We need an intervention system. We've got to help these people. We need to strengthen our power of attorney laws. We need the OSDM. So then what happens next? We get the Elder Abuse Task Forces, 2 of them, 2012, 2013. They issue reports. Who's on it? Between 2013 and 2012, you look at this, which you will receive these PowerPoints later. They'll be on the Aging website. You see very little difference here. Very little difference. Maybe 1 or 2 players added, maybe a couple fell off, but essentially the same group. So we go from 1 year to the next year, same people, recommendations. What do we have in 2013 to add to it? We have a lean event. Bob Welsh, I know, is on this phone call. He was a member of the group. You'll see him. We called it All About Bob. There's Bob. So this group is rooted in government agencies. So you've got representatives from DHS, DIA, Attorney General's office, I'm in there. Aging is in there. You've got advocates. You've got people in AAAs. You've got consumers like Bob. The purpose of this group was to inform the 2013 task force, essentially to kind of boil things down, give them a roadmap, so that they didn't have to sit in the room and figure out what exactly the agencies were doing or not doing, what was happening out in the world, what was lacking. It gave them information so that they could save some time and really get down to the nitty-gritty. In that lean event, we looked at the existing processes for dealing with elder abuse in the law.
I'm going to show you some of the charts that came out of it so you understand the system. This is what we handed to the task force. Let's start with aging. What's their process look like? That you can't read the boxes is not the point here. It's just to see how does it flow, how much work is going on, how does it work. That's aging. All right, you know, not too bad, right? Then we get to DHS. It's getting a little bigger, a little more complicated. Now we've got 3 different systems. We've got more boxes, we've got more shapes, we've got a lot more things going on. Then we get to DIA. We've added quite a few boxes. We've added complications. At this point, eyes glaze over. There appears to be a lot going on. Where do they all intersect? Who knows? We put these all together, and what do we get? The system. That's what the system looks like. So that's what we hand to the task force. This is what we present to legislators and say, here's what's going on. Please understand that we need some help here, as do the older Iowans that we are trying to protect. And I think it's a little interesting. It looks a lot like the mousetrap game board. Just, you know, just as an illustration of how to make things more complicated, we apparently are pretty good at that. So in the lean group, we map out these processes. We share with everybody what's going on. We, too, make recommendations. What did we see? This is the list of our basic conclusions. Fragmented, complex system, which you can see from those maps. No single point of entry. Too many referral points, too many doors that a person can come in and out of. No elder abuse law. We have dependent adult, not elder abuse. No standardization between agencies. You saw that. Very different systems, very different ways of handling reports. Multidisciplinary teams exist, but we don't utilize them consistently. We don't use them across the board. Some agencies don't use them at all. A lack of awareness of elder abuse, a severe lack of education. We have problems with recognition. We have problems getting reports in. We have problems when we do get reports. We have problems dealing with victims when they're standing in front of us. And also a big one, confidentiality restrictions. It's understandable that in this system people's rights need to be recognized. They have privacy rights that must be recognized. But when we looked at these systems, what we realized, and some of us knew, was that we can't even talk to each other. So when you have a person who comes in the door, they tell their story not once, but twice, 3 times, 4 times, 5 times, sometimes 15 times. They're telling their story, which re-victimizes them, number one, but is also inefficient as a government process. I can't call a person up at DHS necessarily and say, okay, what do you know about this person? What have you done for this person? What should I do for this person? We can't sit in a room and share our information. We have to gather it independently, analyze it independently, deal with it independently, which really, again, makes us inefficient and doesn't serve the victim best. So the lean group says, here's what we see, and they pass this again to the task force. Task force comes out 2012, 2013. If you studied these, you'd see in the 2013 task force report, every recommendation refers to a recommendation out of the 2012 task force report. They are the same. As Kim said earlier, maybe 2013 is a little more nuanced, but they are the same. Do these look familiar? Yes, they are the same as the Elder Abuse Initiative report recommendations. An elder abuse definition is needed. We need an intervention system. We need to help these people get in the system, get through the system, and out of the system. We need to strengthen our power of attorney laws. We need the OSBM back. Same recommendations. So what have we done? The Elder Abuse Initiative. We've done the lean group. We've done the 2012 task force. We've done the 2013 task force. We get to the 2014 legislative session, and we're excited, right? Maybe all is not lost. We've got traction. And then sort of starts to take a nosedive, as legislation often does. But we're excited. We're optimistic. 2239 comes out, as introduced here, this is how an older individual was defined. An older individual means an individual who is 60 years of age or older. Many of you in this group will recognize where that age comes from. It's from the Older Americans Act. It's the federal law, 60 years and older. So what's the point of 2239? Let's be consistent with the federal law. That's the mandate put on aging. Then we have 2239 as passed. It now becomes a vulnerable elder. And it's a person, we stuck with 60, we got 60 years of age or older, but we've added an element of unable to protect himself or herself from elder abuse as a result of a mental or physical condition or advanced age. I don't know about the rest of you, but I see it and I think that looks quite familiar to me as well. That to me looks a lot like dependent adult abuse. So now we have another definition. A vulnerable elder, but we're saying instead of being 18 and older, you've got to be 60 or older for this one, but still unable to protect yourself. There has to be an element of dependency, and Kim can speak to this as she was over there all the time lobbying on it. This was a major, major point of contention. This was, in my opinion, the trampoline that made the bill bounce. Much disagreement over the age, first of all. As you can guess, you start to put 60 in there and it hits a little too close to home for a lot of people, and they think that 60 is too young. I think many of the discussions that went on was, you know, pick a number, find one that works. We're talking about individuals here, so you can have a 50-year-old in need of help, you can have a 30-year-old, you can have an 18-year-old, as our dependent adult abuse chapter illustrates. So pick an age. People were very uncomfortable with just picking an age and not having this vulnerability added to it. They didn't like that you could have a 60-year-old out there with no issues, and if something happens to that person, let's say you steal that person's car and they're 60, all of a sudden you're charged with elder abuse, even though there's nothing really that makes that person different than anyone else other than his age. This is a major point of contention. So this is where we landed. This is what your current law is. 60, unable to protect himself or herself due to mental or physical condition or advanced age. All right, so then, as I discussed earlier, the Elder Abuse Initiative report comes out and says we've got a financial exploitation problem, and I think many of us have talked about that for years. 2239 comes out as introduced, says let's add a definition of financial exploitation, and I can tell you that a lot of work went into coming up with this definition. As Kim said earlier, it's very complicated. As introduced, a person commits financial exploitation of an older individual when the person stands in a position of trust or confidence with the older individual and knowingly and by undue influence, deception, coercion, fraud, breach of fiduciary duty, or extortion, so got to be something bad, right, bad motive, obtains control over or otherwise uses the benefits, property, resources, belongings, or assets of the older individual. Here we are trying to address current law problems which require that you use it for your own benefit, your own gain. Therefore, if you took the money and gave it to your child, there was always an argument in court that you didn't benefit yourself. So we think there's a winner here. Not so much. We also defined position of trust or confidence, right? Because we've been having issues with what is that? Who are we going after here? We defined stands in a position of trust or confidence, meaning there had to be a relationship between the two. A parent, spouse, child, relative, joint tenant, a fiduciary relationship, specifically a financial planning or investment professional to cover insurance agents, securities agents, those types, a beneficiary of the person, a caregiver, of course, and then more of a catch-all provision, a person who is in a confidential relationship. And it says, as you can see, that the determination of that confidential relationship is an issue of fact to be determined by the court based on its view of what's going on. So, you know, you've got a neighbor who's a very good friend, has been a friend for 20 years, might not meet any of these other categories, but definitely has an in with the older person. All right, so we set it up this way. Again, not necessarily going to work out for us. So as passed, the definition of financial exploitation has changed, again, to go back to the vulnerable elder. So we're back to someone who's 60 or older and has some kind of dependency. So a person who otherwise is able to take care of him or herself but is unduly influenced by someone, which happens quite regularly, is not going to fit this. They're not. In order to fit this, we're going to have to say that there is something, there's a deficiency with this person, there's a vulnerability, there is something about them that they can't take care of themselves, which has, in my opinion, very broad impact on these cases. That has changed. Importantly, here's the big one, a change to the position of trust or confidence. It was amended to say parent, spouse, child, relative, a caretaker, but can't be somebody in a facility because we don't want the, we've decided we don't want the employees of care facilities included in here because we want to keep them under 235E. We kept a person who is in a confidential relationship. Here's the big change. Amended to say that a confidential relationship does not include a person who's in a legal, fiduciary, or ordinary commercial or transactional relationship with the vulnerable elder. Not banks, not lawyers, not any of the regulated professions. So basically, yeah, no attorneys, banks, insurance agents, securities agents, or real estate agents. None of the regulated professions. Plopped them out. All right, so there we sit. We've just taken out a large group of people who commit financial exploitation against older Iowans. What difference does it make? It irritates me, I'll tell you that, but what difference does it make? Because they also stripped out the crime of financial exploitation. So we had a lot of effort here to exempt regulated industries and regulated individuals from nothing. There's no crime of financial exploitation. So we have sitting on the books now no crime and an exemption. Ripe for whatever happens in the future. If we want to add a crime of financial exploitation at some point, we still have the exemption sitting there. So those people, the attorneys, the banks, the insurance agents, securities agents, and real estate agents and other regulated professionals are not included. What is left then? What is the relief I referred to at the beginning of this? We'll try to find something positive here. There are civil protective orders. That is the bulk, that is the gist of the of 2239, civil protective orders. Again, they apply only to vulnerable elders, so 60 years or older with a dependency. On a positive note, it does allow for a substitute petitioner. So for those who are unable to go in and protect themselves, it allows a family member, a fiduciary, those types to go in and petition for a protective order. Unfortunately, we have that exemption. That exemption applies across the board. So the same regulated professions and individuals are exempted from the protective order. So if you have an insurance agent who's exploiting, for example, can't get a protective order against that person. Again, on a positive note, it allows for temporary, emergency, and permanent orders. Very importantly, very different here than, say, the domestic violence orders. It allows removal of the defendant from the home and requires possibly that the defendant find alternative housing for the victim if that's an issue. It also provides for law enforcement assistance. So it has some mandates as to what law enforcement officials must tell the victim and how they must assist the victim. It also provides for the return of funds that are stolen and allows the court to order prohibitions on the transfer and use of funds that are stolen from the victims. So this is good, as Kim said earlier as well. There are some steps forward here. This is a step forward. This is modeled on the domestic violence orders, but is pumped up a little bit from there. Allows some remedies that otherwise you could not get. But my guess is that this will, I don't know how it will be used. My guess is that when it is used, it will face some challenges. Depending on how it's used, it will probably more benefit those who are in a physical violence sort of situation. But again, vulnerable elder is essentially the same definition as dependent adult abuse. So my guess is that if you have a vulnerable elder who is being physically abused or sexually abused, whatever it is, I'm not sure why a person wouldn't go under 235B instead of using 231F. The only difference is if you can't get DHS to assist and you're not dealing with a traditional caretaker situation, this will allow a little more room there. So a family member could come in and say, I can't get DHS to help. They say this is not a caretaker, so I'm going to go under 231F and give it a try. There will be forms. Judicial has already contacted me to start working on the forms. They are required by law to provide forms and to provide assistance. But the first people going into this there will be a learning curve. And as I said, there may well be some challenges, so it will be interesting to see how that works out. Another element of 2239, a positive note at least for the Attorney General's office, we had a large issue which we discussed at length in the lean exercise and in both task force meetings or task force group meetings. We have a big problem with rejected dependent adult abuse cases, and I know a lot of you out there are probably saying, absolutely, we have a problem with it. It's one of the biggest complaints that I hear. I made a report and it was rejected, and I don't understand why, and I don't know what to do now. The rejected DAA cases are those that do not meet the dependent adult abuse criteria. So DHS says there's not a caretaker. They say that the person's not dependent. Whatever the deal is. They say they don't meet the criteria. Whatever it is, that case gets rejected. The problem we've had in the past is once that case is rejected, from our viewpoint, that person is now in no man's land. So ironically, oddly, there's almost a benefit to not having a person report something to DHS if it's on the line. Once that rejected case comes out of DHS, it doesn't come out of DHS. It's stuck in there. It's confidential. There are a very select few people who can ever see those reports. They are referred to the county attorney's offices, where largely they are unreviewed. It's just a resource issue. It just is the reality of the situation. The only people that can see those reports were the subject, DHS, an approved by DHS multidisciplinary team, a mandatory reporter who reported it, registry personnel, and the long-term care ombudsman. Otherwise, none of us could know about it. And in fact, as to the Attorney General's office, there is a provision of the code that said only the attorney who represents the Department of Human Services could see those rejected reports. We were able to get that provision changed. So the law now says that attorneys in the Attorney General's office may access those reports. We still have the issue as to how those people receive services and what we do with them, but that is something we have to deal with going forward from here. So we did get a small confidentiality change. I am not representing here that it at all addressed the issues raised by many in the lean group and on the task forces. That does not address the issue of a person having to make 20 calls and tell their story 20 times. It does not address the issue of us all being able to sit in a room and share the information that we know and that we have gathered and that we want to know. It doesn't address that at all. So it's a small step, but it is a step. The last part is that the law requires an agency collaboration and report. What does that mean? That means that these 5 agencies, Aging, DHS, DIA, Public Health, and the Attorney General, are required now by law to get together and collaborate. That to me looks a little bit like what we've been doing for a number of years in the past, but there's, I guess, a slight difference here. They are required to collaborate, and they are required to provide written recommendations, which again looks a lot to me like what we've done in the past, but this time it's just these 5 agencies. And basically the point, I believe, is to get down where the rubber meets the road and to say to these agencies, you've got all the information you're ever going to get. We keep coming up with the same results and the same answers and the same recommendations. Here they are. What are the 5 of you going to do with them? The purpose is to look at strengthening elder abuse prevention, detection, and intervention efforts. Nothing new there. But again, I think the point is to say the 5 of you will sit down and figure this out. They are also, these agencies, supposed to tell the legislation what the relevant budgetary issues are. So if the problem is resources, supposedly the legislature wants these 5 agencies to say, here are my resource issues. I need $500,000, I need $1 million, I need $10 million, I need $15 million. Tell the legislature what it is you need. Importantly here, I think this is supposed to be the big fireworks part of it, is if there is no agreement, each agency is required to provide a written report and an explanation of why it is they cannot come to agreement. I guess we'll see how that works out. The agencies, I believe, are scheduled to meet in July for their first meeting to figure out how they're going to meet. So that's the deal. If they can't come up with a unified recommendation to the legislature, then each one has to say what the problem is and why they can't agree with the other agencies and who are the holdups and what are the holdups. This unified recommendation or the separate reports are due August 15, 2014. That's coming up very quickly, as you know. The point of this due date is to make sure that these agencies can figure out and get information to the legislature prior to the 2015 legislative session, which I'm sure Kim is most excited for, which will be starting, September. So we're going to start right back over. It feels like we barely finished 2014, and here we are again. So that's due August 15th. And as I said, the agencies have not yet met. And that is what I have as to 2239. I think we're handing it over to Margaret to talk about power of attorney loss. But one thing before I finish, someone had asked me, and they have to leave this webinar, but asked me to address this in case there are others who can't stick around. This law did not change, and nor does the Power of Attorney Act, which Margaret will talk about, the attorney-in-fact priority over guardians as to health care decisions. So those of you who deal with this regularly really should listen to Margaret's updates on the POA to make sure you understand what changed and what hasn't. So thank you all for your attention, and we'll bring on Margaret.
Hello, this is Margaret Van Houten. I'm going to try to do this to get my PowerPoint on the system, and I think that we're doing this now. I am not knowing whether my PowerPoint is showing at this point. Is there a way that someone can send me a chat?
Margaret, your PowerPoint is showing.
Okay, thank you so much. Well, I'm so happy to be here today and talk about the new Iowa Uniform Power of Attorney Act. Many people have been involved in getting this passed. This Uniform Act was first approved by the Uniform Law Commissioners in Philadelphia with all sorts of input from different interest groups in 2006, I believe. And we have talked about, when I say we, I mean we in the Bar Association have been talking about implementing it, but have not really we did not become, I would say, passionate about it until we saw so many instances of abuse and need for guidance for people who are acting under powers of attorney. More and more people are acting under powers of attorney, and than probably has ever been the case before. So about 2 or 3 years ago, we in the probate section of the Bar Association instituted a study committee to look at the Uniform Act and see how it would fit in Iowa. We did make some changes from the Uniform Act that I'll talk about as we go along, but basically this is the same as the Uniform Act, and this is similar to other acts that we have, such as the Uniform Commercial Code, the Uniform Principal and Income Act, the Uniform Trust to Minors Act, Uniform Transfers to Minors Act. I know a lot of us have custodial accounts for kids and grandkids. All of those are the result of Uniform Acts, and the best reason for using these Uniform Acts is so that you have some uniformity among the states with respect to what people can expect and with respect to how they handle their business and other matters. When we were at the legislature, we thought we were going to have very little problems with getting it passed, but it turned out that we did have some issues. Primarily, the primary issues were technical, legal technical issues, such as how does the effective date deal with current powers of attorney. We had quite a bit of discussion about how banks and other financial institutions need to treat agents under a power of attorney. But luckily, we were able to iron all of those things out. And when I say we on that, I mean a very broad range of advocates on behalf of the Uniform Power of Attorney Act, including legal, banking, trust people, and most importantly, I think, are the advocacy groups for the elderly and people who are those of you who are listening to this. Your organizations worked very hard to get this passed, and I'd like to thank you. Also, before I get started, I want to thank Josephine Gittler over at the University of Iowa. She has done an excellent and very hard, a lot of hard work on getting this passed, and not only her intellectual abilities, but her just pure persistence provided us with an ability to get this passed. So anyway, the purpose of the Power of Attorney Act is to create a comprehensive framework for the creation and use of powers of attorney, and this is financial powers of attorney only. The Act also can be used to prevent, identify, and redress power of attorney abuse. As I just mentioned, this is a very serious problem, and I think that between the Elder Abuse Act we just were talking about and the Power of Attorney Act, Iowa has taken a very large step forward in making it more possible to not only prevent abuse, elder abuse, but also to give people specific guidance about what is okay and what is not okay to do. When I was preparing this presentation, and the slides that I have are from a presentation I made to the Bar Association last week, I will skip over some of the technical legal things, but I think that everyone here will benefit from talking about some of the legal issues of this act as we go through it. But I thought instead of just going through the statute in order, I would address what I think people might want to know from a practical from a practical basis, basically for first things first, and then also to when I talk about recommend to clients, this is stuff that you all will be able to recognize then as you're dealing with powers of attorney. There is a resource about the Uniform Act, and that gives a lot of explanations about the Uniform Act, and this is from the American Law Institute, which is the sponsor of all of these uniform laws. And the website is uniformlaws.org, and it's a wonderful resource. And once you get there, then it says enter the name of your act, and you would just put in Power of Attorney Act. So it will give you all sorts of information. It can link. It tells you what states have enacted the Uniform Power of Attorney Act in what state, and gives you other information about the act, including comments on the specific legislation as far as why the uniform commissioners created one way of doing things instead of another way of doing things. So I'm going to go through my PowerPoint, and then I'm going to go through the actual statutory form of power of attorney that is going to be enacted, that can be used by people who do not necessarily want to go to a lawyer or may not have the funds to go to a lawyer to get their power of attorney completed. And this is going to end up being very similar. This form will end up being very similar to the healthcare power of attorney and living will that people can get online. The Iowa Bar Association is currently working to get the statutory form put on the Bar Association's website so people can download it, fill it in, and end up having a power of attorney. One of the things, as you can see on the current slide, is that the Act's effective date is July 1, just next week. And the question is should any of us update our own powers of attorney as soon as possible after July 1? The Act is effective to all powers of attorney regardless of when they're signed. So the mere fact that we have new legislation does not require that you update your power of attorney in order for it to still be effective. It will still be effective even if you signed it 20 years ago. My general rule of thumb is that people should update their powers of attorney every 5 years, and that's just the reason. The reason I say that is that banks are less worried about newer documents than they are about older documents. So you would have more of a. I think it's easier to get a new document approved by a bank or accepted by a bank. So just in general, I think someone should recommend updating within 5 years, every 5 years. And you don't need to rush out. But there are some reasons why you might want to either recommend updates or update your own. First of all, the Act has changed from current law. If you get a new form of power of attorney, it will dovetail with the Act, and it would make any sort of interpretation of the power of attorney easier by the court. Again, though, and also a new power of attorney will not have any problems or any perceived problems with the effective date provisions of the law. As I said, we do not think there would be any effective date provision issues, but one thing I've learned in 35 years is you never know in the legal profession. It also, I think it's a good way, especially for us lawyers, to ask questions of clients maybe we should have asked before with respect to powers of attorney. I think in the estate planning area, we have a tendency to pay a lot of attention to what happens upon death of a client with respect to what what happens to their property, and what are your last wishes, and that sort of thing. And we ask so many what ifs when I do a will or a trust for somebody. You know, what if 35 members of your family die before you do? Where do you want your property to go? Well, that is, you know, very unlikely to happen. Yet I don't spend, historically I have not, I do now, but historically I did not spend a lot of time going in great detail as far as what clients may or may not want their agent to have authority over in a power of attorney. And you know, as I say, there's a very high chance that if you have a power of attorney, someone is going to have to act under that power of attorney. So
Margaret,
yes.
people are having a difficult time hearing. If you could speak up, that would be appreciated.
Okay. Is this
Thank
a little
you.
better? Is that better?
No.
No. Okay. I'm going to try to put this on my speakerphone. I'm on what's that called, a headset. So let me change that. Hello, I am back.
Thank you, Margaret.
Can you hear me better now?
Maybe slightly.
Okay, I'm going to just pick up my phone. Is that better?
I think it's clear.
Okay,
Thank you.
very much. I apologize for the pushing the wrong button on my telephone. I'm a proud member of 2 or 3 technology committees, and I can't seem to get it to work sometimes. So thank you, and I'm just speaking into my headset right now. So if there are any questions, please let me know if you are having any problems. Okay, so again, I think that I'm going to backtrack a little bit to say that having this act passed is a good way to perhaps look at the powers of attorney that we have and see if our clients, give our clients more choices as far as what can be done and what should be done. So I think that it's a good opportunity. Of course, I don't want to make this into too expensive a proposition for people to update their powers of attorney, which is why I am generally I'm not getting too upset if people are not going to update their forms right away. Also, the current forms that we have may not adequately address some of the conflict issues that we have. You know, for instance, if you have a principal, who is the person who assigned the power of attorney, who names a child as an agent, and that agent is also the farmer of their farms. And what if the cash rent on that farm is below market value? The power of attorney needs to address that, and that is not specifically addressed in the current bar form, nor is it addressed in the statutory form of the new act. But this is a good time to look at the potential for dealing with some of this conflict and self-dealing matters, so that the actual form of power of attorney is appropriate for the situation. One of the nice things about the Act is that it has a very long and very detailed list of powers that agents have. And you know, it's a several section and several page long list. You know, so it says real estate powers. You can sell, you can lease, you can borrow, you can mortgage, you can do all sorts of things with respect to that real estate. Grant options. You can, you know, so all of this list is a very good guide for people, and we think that the actual listing of powers, this is like trust powers or powers to an executor. It's something that we have a good list in the statute that was not there before. And the nice thing about it is you don't have to retype it into the new form, and the statutory form just has an authority to, as they call it, incorporate the statute by reference. And again, reasons you might want to not worry about updating your forms right away is the fact that the Act applies to POAs whenever they are signed. The current bar form, the Iowa State Bar Association form, is detailed, and it's very similar, although it doesn't have some of these conflict resolution things that not conflict, conflict of interest items that I was talking about. But the current bar form is very detailed and basically will cover most situations. And again, as I said, it may be more costly for clients to just update their form without doing anything else. I think what I'm going to do, and I know I have not even a week to do this before the effective date, but I think I'm going to contact my clients or send them a letter or an email saying that they have the opportunity to use the statutory form, and just send them the statutory form that they can either come in and sign or sign themselves. I would do this for clients who have very standard estate plans where they don't have a lot of authority to make gifts and that sort of thing in their powers of attorney. But for most of us, the statutory form would be easy, and this would be a no-cost ability for the clients to update their powers of attorney now without it costing them too much. Now, as I said, and we'll go through the statutory form again, we'll go through it in detail, but the statutory form is appropriate for many, and I probably would say most situations. First of all, when an individual's assets are not complicated, so if you have someone who owns a home, who has life insurance, who has a retirement account, bank accounts, and you know, just basic investments, and not an unusual family situation, the statutory form is probably going to be very, very fine. The good thing about the statutory form is it does give directions to the agent within the terms of the form that will be very helpful. Also, when the succession of agents is simple, you know, so if you say, I name my spouse, and if my spouse is not available, then I name my daughter, that's a very simple succession of agents. If you say, I name my spouse and my oldest child, X, as my agent, and if my spouse is unable to act, then no one will succeed my spouse, but if my oldest child is not able to act, then my next oldest child will step in. That succession of agents is relatively complicated, and trust me, they do get more complicated than that. And at that point, the succession of agents is more complicated, and you might want to use a customized form. And usually the customized forms are viewed as, you know, the legal documents where it's good to have a lawyer at least look at that type of form. Again, customized form would be more appropriate if you have a potential conflict of interest, if you have the agent being a child who is in business or in farm operations with the principal, and if substantial and ongoing gifts are contemplated. So if you have someone who has a substantial estate and they are generally making gifts to children, to grandchildren, creating entities for estate planning purpose and that sort of thing, it's much better to have a customized form. So basically, if there is anything that anyone would suggest that's complicated, you would want to have a customized form. Our firm is going to make both available to our clients. So if you would come in and do a will with us, you would have a power of attorney, and we would talk to you about whether you would use the statutory form or the customized form. We'll have both available. The customized form will be updated to take account of the new act, but it will have many, many choices that are available with respect to gifts, with respect to creating or terminating trusts, that sort of thing. Of course, when you get to that point, you have to deal with the issue of how much do you trust the agent to make these gifts and do estate planning, and then what type of oversight are you going to grant in the customized form for someone who is acting under a power of attorney. So then the next question is, should the listing of powers be listed in the actual power of attorney form, or should it be incorporated by reference? The statutory form incorporates by reference. A lot of customized forms will probably also incorporate by reference. So you can say my trustee shall have all of my agent shall have all the powers granted in Iowa Code section 633B, and then there are certain sections, 204 through 217. The nice part about it is that it's brief. The clients don't have to read a whole long sentence. But one of the problems with that, which is the same with any sort of will that has a trust in it, does the client know by that incorporation what powers are being granted? I think probably if we do any incorporation by reference, we are going to provide our clients with a separate list enumerating those powers so that they can look at it and say, well, I don't really want my agent to be able to mortgage my home for my care. And in that way, the clients would have an opportunity to actually see what powers are actually being granted, even if the form only incorporates by reference. One of the most important things to know about this Power of Attorney Act is that it is what's called a default statute. Most of the provisions can be changed in the provisions of the Power of Attorney. So basically, a non-relative agent, for instance, cannot make gifts to themselves. But I could say in my Power of Attorney, I name my best friend Joan as my agent, and I specifically authorize Joan to give herself up to $10,000 a year, because I would have been doing that anyway. So I can, even though the statute does not authorize it, I can, in the Power of Attorney, verify the rules found in the Power of Attorney Act. There are certain things that cannot be waived, but it's not very much. And this thing of the duty to act in good faith within the scope of the Power of Attorney and in accordance with the principal's expectations, that is what can't be waived. This fiduciary duty is a little less stringent than what the common law in Iowa would produce. So this is going to be a bit of a change and a bit more liberal as far as what duties can be waived. But of course, it needs to be specifically waived. It can't be. These are things you can't waive, but the other things that can be waived, have to be specifically waived. Here are some things that I could change in my power of attorney. So for instance, a fiduciary duty includes acting loyally for the principal's benefit. Now that would generally provide that I could not rent land at a discount to a family member, because that's against my personal benefit. But if I say my agent can rent to my nephew at less than fair market value in the power of attorney, that's a fiduciary duty that is overridden, and that would be fine. As I've talked about already, the conflict of interest can be waived. So let's say that I name my daughter as my agent, and she and I have a business together. I can say my daughter shall continue to be authorized to pay herself whatever compensation she thinks is appropriate in the company, and regardless of the fact that that might be a conflict of interest in her duty to me as my agent and her duty to the company. Now, you can waive the duty to act with required care and competence. We don't generally wouldn't recommend that anybody avoid that, and I've been having a hard time figuring out when you would ever recommend waiver of that requirement. And then attempting to preserve the principal's estate plan. This is something that can be waived, but something that all of us need to remember, that it is a general duty under the Act. So if I have a will that leaves everything to my daughter, and I name a third party as the agent, unless my power of attorney specifically says my agent does not need to preserve my estate plan, the agent must, under the law, make sure they don't change a beneficiary designation, let's say, or you wouldn't have the power to revoke a will, but change a beneficiary designation or put assets into joint tenancy. You guys have seen that all. I know you all see that all the time, where someone is the agent under the power of attorney, and a bank account all of a sudden shows up as being in the joint names of the principal and the agent, instead of the agent listing themselves as an agent. The general rule, and this is something that you all, again, run into all the time, is whether the agent can make gifts to themselves or to anyone else. Section 217 of the Act provides the basic rules of when an agent can and cannot make gifts. Under the statutory form, there is no specific box that authorizes the agent to make gifts, and we in Iowa made that duty required. In the Uniform Act, there is a line there that authorized the agent to make gifts under Section 217 of the Act. Even though those gifts are quite limited, we decided that the general rule under the statutory form should be that the agent does not have authority to make gifts. But if an agent is granted authority to make gifts under Section 217, an agent who is not a close family member, which basically is an ancestor or descendant, the agent may not exercise the power in favor of themselves or their family members. A family member who is granted general authority to make gifts under Section 217 can make gifts in an amount up to the annual exclusion each year which would be the $14,000 a year. So if I gave general gift making provisions, so if my power of attorney said my agent has the authority to make gifts, then my daughter could make gifts of up to $14,000 a year to herself. But again, as I said, if it was my niece who I had named as the power of attorney, that general rule, authorization to make gifts, does not authorize her to make gifts to herself. Generally, though, the definition of gift is very broad, which includes changing beneficiary designations, putting property in joint name, creating a trust, changing the beneficiary of a retirement account, or disclaiming property if that disclaimer results in a transfer of money to the agent. A gift also includes gifts to transfers to minors and transfers to a college savings account. And also, since the people I've dealt with who have abused their authority under the power of attorney seem to be very creative in how they get money to themselves. The Act is very broad, that the listing of indirect gifts is not intended to be exclusive. So that means that if someone, I'm trying to think of, I had one case where the niece did transfers, a very complicated set of electronic transfers that ended up in her account. That may be more of a direct than indirect gift, but it was very complicated and complex what she did, and so that would, under this situation, be treated as a power to make gifts. A lot in my world, we do a lot of gift splitting between spouses, and that means so that instead of $14,000, you have $28,000 a year you can give. So let's say that I'm married to someone who has enough money to make those large gifts. My agent can consent to the splitting of those gifts, so that my husband could give $28,000 to his children, and then my agent under my power of attorney would consent to that. That doesn't reduce any of my money by consenting to it. It just uses my annual exclusion with respect to that beneficiary. And also, any gifts must be consistent with the principal's objectives. And the best reason to know about what the principal did in the past is to look at what the principal wants to do is to look and see what the principal had done in the past. So if the principal had never made gifts, it would be inappropriate to continue to start a gifting program, unless it's a situation where it's all part of a larger estate plan. But generally speaking, if someone never made gifts other than the $20 in the birthday cards every year, that's not appropriate to change to a $10,000 gift to the agent, even if the agent is a child and there is general authority. And then, even if you don't know what the principal meant, you look at the list of what's going on in the principal's life with respect to making gifts. How much money does the principal have? Can the principal afford to make these gifts? What's going to happen in the principal's life? Does the person have an early, well, probably does have an early or some sort of dementia disease, and this might have the need for long-term care. Is there a need to save taxes, either income or estate taxes? Will this help with the eligibility for a benefit, a program, or assistance And then again, as I said, the principal's personal history of making gifts. Also, as I said, that the statutory form does not include the ability to make gifts at all, but it can be added to the form. And then if complicated gifting is anticipated, the standard form is not appropriate. So the question, I'm kind of getting back to the beginning of the Act now as far as what it provides. And generally, the Power of Attorney Act applies to anything that is giving someone else the right to make decision-making over financial affairs, except what they call a power coupled with an interest. And that's so, for instance, if you have pledged collateral, you give your creditor the right to take certain action with respect to the property that is collateralized. That's not covered by this Act. Similarly, the healthcare power of attorney is not covered at all by this Act. Chapter 144B deals with that. Proxy rights or voting trusts are not dealt with by this Act, nor is a government form for a government purpose. So the ones I think about that I see government forms are the power of attorney for the IRS or the Iowa Department of Revenue, the power of attorney forms on the government program payments, and I'm sure there are other powers of attorney for government purposes that are not covered by our state form. There are new things in the Act that we need to keep in mind. First of all, the power of attorney must be acknowledged by a notary. This is not any form that you see that is old even has the you usually see that it's acknowledged because in order to transfer real estate, there must be a notary signature or some sort of acknowledgement. But the current law does not require notary acknowledgement. New law does. Now, if you have an old power of attorney that is not acknowledged, that is still correct. That will still be effective under new law because the effective date provisions specifically provide that the issue of effectiveness of the power of attorney is determined by the law of the state in effect at the time it was passed. So this is not a reason to update your power of attorney if it's not notarized. The power of attorney revokes almost all prior powers of attorney. Under the Uniform Act, old powers of attorney are not revoked. So let's say that I have a power of attorney that I did in 2001, and I do a new one now under the Uniform Act, that national act. I would have to specifically revoke that 2001 POA. Now, under Iowa law, we just wanted the default rule to be that old powers of attorney are automatically revoked. The ones that are not revoked would be powers of attorney that are with respect to a specific transaction. So, for instance, if I'm going to be traveling in Europe and I'm also selling my house at the same time, I could give an agent the right to sell my house, and that if I did a new general power of attorney at the same time, that specific authority is not revoked. For years, we talked about the attorney in fact, and that person is now called the agent. I'm very happy about that because the word attorney in fact gets all confused with the legal community as opposed to the word agent, which you don't have to be an attorney to be an agent, nor did you have to be an attorney to be an attorney in fact. One of the good things that has changed is that we use the word incapacity when determining whether someone has the ability to act in a particular role, either whether the principal is incapacitated or if the agent is incapacitated. Disability has a much larger subset than incapacity for this purpose. Historically, a power of attorney was assumed to be not durable. And durable means, durable means that upon disability, the power continues. So historically, you were unable to have a power of attorney that survived the principal's disability. So powers of attorney were used on a much more short-term basis. And then the statutes came up across the nation that authorized a power of attorney to survive the principal's disability or incapacity. So no longer do you need to specifically state, though, that the power of attorney will survive disability. It used to be that you had to specifically state it. The statutory form does not specifically state that it will survive disability. I will be interested to see what the Bar Association form says about this, because we lawyers have a tendency to worry, even though we don't have to say that we don't have to state that it's durable. I think that we probably will have a lot of lawyers and maybe even the Bar Association who says that we need to state that it is durable. Again, this is one of my favorite sections of the Act is 633B.116, which is a laundry list of individuals who have the authority to request court review of the agent's action. Before this act, the only people who could request court review of an agent's action were the principal, who in most instances was incapacitated, and the principal's conservator. And in most instances, it would be difficult to get a conservator appointed for that purpose because the agent under the power of attorney would find themselves as the conservator, or would that person would resist the appointment of the conservator. And in many instances, especially those that you all see, it would have been difficult to go through all of that expensive court action in order to request the court review of the agent's actions. So the DHS has the authority to request court review of an agent's action. Almost any family member, a caretaker, a banker. I, of course, did not write all of this down here. Let me find this, because I think that the laundry list is very important. Okay. Yeah, the principal can ask, the agent can ask, the agent under the health care power of attorney can ask for court review. The spouse, parent, descendant, and if you don't have any of those people, the presumptive heir. So if I have no children or no spouse, perhaps my sisters could do that. The beneficiary of any of my property, a government agency, and Iowa law specifically added that I can name a person who has the authority to request court review. So let's say that I'm naming my daughter as agent, but I want my stepson to have the authority to request a review of her actions, so that I could specifically put in the power of attorney that my stepson has the authority to request court review of the agent's actions. Now, we were pretty worried, not only, I mean, we thought it was very important to have this strong list of people who can review, but people were also worried about, well, what if somebody's just a troublemaker in one of these positions? So we specifically provided that the principal can be reimbursed for costs of any of these actions if the court determines that it was not a good reference. So people cannot act without cause or without good knowledge, but there is the potential for attorney's fees being allowed. If the agent does violate the act, there is specific liability of the agent for damages and for attorney's fees. Section 633B 115 does allow an exoneration provision. This is similar to what I was talking about earlier, but I cannot say that my agent is allowed to act in bad faith or in a proper motive. Basically, you can hold them to a negligence standard. You can say, if my agent acted negligently, that's okay, but they can't act in bad faith. We would not recommend including this clause in. It is not in the statutory form, but it is something that a principal can put in there. And the effective date is generally the date of execution. So I could say that an effective date is in the future. So if I sign something today, I could say this power of attorney shall be effective on July 1, 2014. If I don't say it is effective on a particular date, it would be effective on the date of execution, and I don't think you could make it so that it is effective retroactively. One of the big things of third party of this is getting the banks and other financial institutions to accept a power of attorney, and that has always, if you get together with a bunch of lawyers, everyone has a war story about how so-and-so bank won't accept my power of attorney. And Iowa has, for several years, had a statute that requires banks and financial institutions to accept an acknowledged power of attorney, and this, in the new section, continues that. This is pretty much the same thing as what is in the Uniform Act, the National Uniform Act. But to balance that, third parties and banks who accept those powers of attorney are granted relief from any liability if the acceptance was in good faith. So what the banks are worried about is that if someone comes to the bank and says, I'm the agent for Mrs. Smith, and here's my power of attorney, I'd like to withdraw all of her money or have it transferred to a different bank, they are required to accept that. But on the other side, if it turns out that either he isn't the power of attorney or he puts it into an account in his own name, they're protected from liability from the people who should get the money, or protected by liability from the principal as well. So these sections are real important, and we went over those so carefully, and also that was a big issue at the legislature because we want, there was an issue with respect to should a bank be required or authorized to require a form on their own using the bank form. That is not in the Uniform Act. That was something that was suggested at the legislature, and we were able to prevent that because if a bank was authorized to require a form of their own, that in effect makes the power of attorney ineffective. There just is, because if I've signed a general power of attorney and then become disabled, and my agent takes that form in and it's not acceptable, I'm not able to sign a new power of attorney with the bank. So basically that freezes assets until a conservator is appointed. So that's not good. The specific powers generally are, as I said, a laundry list of powers that an agent has unless the power of attorney provides otherwise. Section 203 of the Act is what I call an enabling provision. So it says if Section 204 provides for real estate transfers, Section 203 tells you that you can do anything you need to do to carry out that action. So that would include signing documents, providing financial statements, all sorts of things. Section 203 gives the power to take any and all action to carry out the powers granted in 204 through 217. And luckily, I was correct that Section 204 deals with real property. And you'll see as you just look at these specific powers, what the property is that in each section. There's a specific section even for commodities and options, a specific provision for real property, and the statute will be sent to you as part of my materials or uploaded, however they're going to do that. 206 deals with stocks and bonds. 208 deals with banks and financial institutions. 209 authorizes the operation of an entity dealing with insurance and annuities. Whoops, I'm sorry. You could sue and be sued. Under Section 213, personal and family maintenance, the Uniform Act that we started with had very broad ability to provide services, provide money to family members, and not just family members who were supported by the principal. So, for instance, one of the people on our committee said, it appears to me that an agent can pay for their country club dues out of mama's money. And so we wanted to make sure that the payment of personal and family maintenance be limited to either things that are dependent related, so if a child's education or a spouse's doctor bills or a spouse's housing expenses, as opposed to a grandchild's swimming lessons, unless there has been a continuing a history of paying for that sort of thing, and again, if there's enough money to pay for it. So again, it's the continuation. That's something we looked at very closely, and we'll have to deal with that. I mean, as that will be something we will deal with on each particular situation. Section 212 authorizes the claims and making claims, defending claims, and so that is something that you would want the agent to generally have authority to do. 214 authorizes working with the benefits of government programs. 215 is retirement plans. That's a real great change from what authority we had before, because retirement plans have become so important in people's lives. 216 deals with taxes, including the ability to make tax planning advice, or act on tax planning advice. And again, 217 is the limited power to make gifts, which we have not included in the statute, in the statutory form. And here we're talking about the effective date again. And I'm going to skip over that. I think I do have time to go over the statutory form a little bit. And I was wondering if I could get someone to see if this has been included. This statutory form is on this page now.
Margaret, we are not showing anything.
Okay. Okay. Let me see here. Is that coming up?
No. I can change presenters back to us. We do have the form. Would you like us to do
that would be great. That would be great.
Okay, 1 second here.
How about this? Is that?
Margaret, yes, it's up.
Okay, thank you. Okay, as you can tell, it is, I'm just going down, it's several pages long, so it's not real short, but it is, I think it's a lot easier to read, and someone can, I don't think you need a lawyer to fill this out, I think is what I'm saying. And the thing that I really like about this is on number 1, where it just specifies what the law is, really, and what you need to be careful about. You know, it does not authorize to make health care decisions for you. I mean, people get that mixed up all the time. You should select someone you trust as your agent. Oh, and I forgot to talk about compensation. Your agent is not entitled to compensation unless you state otherwise. And then, I mean, I think that this is just specifically, it just tells them what they need to put in. And then I'm going to talk about compensation again. On compensation, if you name a bank as an agent, the bank is authorized to compensation under the statute. An individual is not entitled to compensation unless you state otherwise. So we put that in because in many states, banks do not act as agents, but we still have a lot of banks who will act as agent in Iowa, and we wanted to make sure that they are authorized to get fees for what they do. But generally speaking, an individual is not entitled to compensation. They are entitled to reimbursement of expenses. You'll notice that you put your own name in and then the name of the agent, and there's only one. The statute authorizes you to have more than one agent, but we did not put that in here since we just determined it would, to make the statutory form less complicated, that you would only name one agent. If you needed to name both, let's say I had 2 children and I wanted them, I would just put the second agent's name on the special instructions. Or I might just on the first page say, child 1 and child 2, and then say see attached or something like that. And again, who would be the successor agent if the first one is unable to act? And they even go down to a third grant if the second successor is unable to act. And then here is the grant of general authority with respect to what kind of powers that are authorized. And you'll notice way down at the bottom it says all preceding subjects. So if you want to give the broadest authority possible, you would you would have them initial, you or whoever's doing it would initial the all preceding subjects. And then there are this specific authority under Iowa law. If you want to change a trust, you can do it under a power of attorney if the power of attorney and the trust both authorize it. And then agree to an amendment, then make a gift to an individual who is not an agent subject to the limitations of the Act. And then make gifts. This is, a person needs to think about making gifts under this form before they would do so. Just to let you know, under Iowa law generally, if this statutory form is completed under the influence of the agent, and the person is is susceptible to that influence, the actual power of attorney can be found to be ineffective, and that can happen through that request to review request for the court to review the power of attorney. And then again, this limitation that an agent who is not the ancestor, spouse, or descendant shall not use my property to benefit the agent or a person to whom the agent owes an obligation of support, unless I have included that authority in the following special instructions. And then here is the special instructions where you can say things like, you say my agent shall be entitled to reasonable compensation, or my agent shall be authorized to give himself $5,000 a year, or my agent shall have the authority to enter into an agreement with himself in order for provision of services, that sort of thing. And then right here is where you have the authority to request an accounting of the agent. The effective date, the power of attorney is effective immediately. That's the general rule. You can make the power of attorney effective upon incapacity of the principal. It's not generally recommended, just because of the inability or difficulty in getting a doctor's statement that the agent is incapacitated. One of the things that you can do is nominate a standby conservator and guardian in your power of attorney now. You couldn't do that in the past. So if you want to name who would have the authority to be your conservator or guardian, you would just put it in this part of the form. This does not repeal the standby, guardian, and conservatorship provisions of Iowa law. You can still do the standalone form for that. My guess is if you had you had a standby conservatorship petition and a different person named in the power of attorney, you're going to have a bit of a problem, but probably the most recent appointment would be used by the court if there was a fight between those two people. And then here we have the signature and the notary. You can put who prepared the document. That would be important for purposes of determining whether it was adequately explained and that sort of thing. And then number 2 here is the agent's duties. This goes over what the agent has to do, and then a laundry list of, so that the agent can't say they don't know what they're supposed to do. So if they say I didn't know I needed to keep a record of all receipts, disbursements, and transactions, they say, well, it was right there in the form. And here are the times when the agent is no longer able to act, of course, on the death, when the principal revokes, and then any other termination. So I could say this power of attorney shall be effective for 10 years, and if at the end of the 10 years it would be revoked. Again, one of the things, if the agent is a spouse, it's not upon dissolution of the marriage where it's revoked. It's upon filing a divorce petition. And then it specifically talks about the liability, and then this section is a provision for a certification form, so that the agent can give a bank or whoever needs to deal with the agent a certification that the power of attorney is still open, is still effective. So I think that is all I have on this, and I think we're going to have a little bit of a few questions. I sure appreciate all of you listening. Thanks.
Thank you, Margaret. So we're going to take some questions now. The first question we have is, I feel like the standards for the elder abuse is ridiculously high. The reason I've been given is that the people I've reported abuse on aren't really dependent, which I vehemently disagree on. Is this a function of lack of funding to pursue these cases?
This is Chantel. First of all, I think what you're referring to there are the dependent adult abuse standards, probably under 235B, and that is something that we hear quite frequently. I don't believe that it's a funding issue. It's just a difference in the way that the law is interpreted by DHS and by those making reports and those looking at the outcomes. There are different workers in each county, and there are different perspectives on what dependency is, and sometimes it's just a matter of raising that issue with someone and saying, you know, from my perspective, I see it a little differently, and then talking through it. But it really is just, you have individuals making these determinations, and that's just sometimes how it turns out. But I don't think it's a funding issue. There's an education issue maybe for some of these people, but it may just well be perspective.
Okay, thanks, Chantel. Our second question, it has been 55 days since the bill was passed, and there is 51 days left for the department to submit a report. When are the department heads and the Attorney General going to meet?
And I believe this question is referring to Senate File 2239, so the elder abuse relief bill that Chantel reviewed with everyone. I do know that a meeting is currently being planned for July, as Chantel referenced. I'm not sure of the exact date at this time. There's a lot of work trying to deal with department head schedules, but it will be planned for the month of July. And just a tiny technical issue on that particular question. Although the bill passed 55 days ago, it really didn't go into law. It was not signed and transmitted until May 23rd. So about 30 days ago is when it officially became a law, and when we knew for sure that there would be a report due.
Great, Kim, thank you. What does the county attorney do with all the dependent adult abuse notices of intake decision when they are not a dependent adult? Do they refer them to anyone, or do they sit in a file because of confidentiality?
This is Chantel again. My understanding is that if they are reviewed by the county, and sometimes they are and sometimes they are not, if they feel that a person was categorized as a rejected case incorrectly, they will take that up with DHS. But if it doesn't meet the dependent adult abuse criteria, the county attorney doesn't have authority to bring a dependent adult abuse charge. Now, the county attorney might look at the case and say, this isn't a dependent adult abuse issue, but this is a theft or some other possible criminal violation, and they could, in theory, submit it to law enforcement to be looked at for another reason. But given that those reports are confidential, they can't be used for that purpose. So that's one of our confidentiality issues. If it's a rejected case
and it doesn't meet the criteria, that's the end of the story for that case, absent a report coming in on something else related to that case.
Okay, when will the full code be published? I can only find 231F.1.
This is Chantel again. The hardback versions of the code are published in the even year, so you're looking at 2016. I talked to Patty Finero about how often the online code is updated, and she said they hadn't started to edit it yet, so probably fall at the earliest. If you want to see the full enrolled Senate file, you can go online to the legislative website, and you need to click. There's an option for, I can't remember all of the choices in there, but one of them is the enrolled version of the bill, and it will pop up and will show you, it's Governor Branstad's letter saying, I am transmitting this, it's signed by the governor, and then the language follows it. So you want to look for the enrolled bill.
All right, thanks, Chantel. So I am understanding that once these agencies get together, DIA, DHS, etc., and make recommendations in August to the legislation, that there will be funding for elder abuse, elder rights for the AAAs.
Good question. That is not accurate. The departments are charged to get together and make recommendations by August, but it is really up to the legislature to determine what to do with those recommendations. Depending on what the legislature does, it may or may not spin out a bill, and that may or may not spin out funding. But it really, once that report is submitted, it falls in the hands of the legislature to determine what to do from that point.
I work with elder abuse clients daily, and those that do not have a POA, I give them a green booklet, December 2007 from the Iowa Department of Elder Affairs, and a handbook called The Guide for Substitute Decision Making in Iowa to help educate them. Will these be updated at some point to reflect the changes in the law? Many, however, are also referred to legal aid to establish a POA. The handbook has a copy of a durable power of attorney or POA for healthcare decisions only, nothing for financial POA.
Thank you for the question. Yes, the Department on Aging has two handouts that you're referencing. One is a handbook on power of attorney, and the other one is a guide for substitute decision making in Iowa. Based on the Uniform Power of Attorney Act passage, both of those booklets are now outdated and will need to be updated based on the new laws. Our legal services developer extraordinaire here in the office, Paige Thorson, is currently working on updating the power of attorney booklet. And then as the Office of Substitute Decision Maker gets up and moving again, they'll need to revisit that guide for substitute decision making as well. So in short, yes, they're both going to be updated. The handbook does not include a financial power of attorney document because, and Margaret jump in and correct me if I'm wrong here, but there has been an Iowa State Bar Association form for healthcare power of attorney, but there has not in the past been one for financial power of attorney, so that is not a document that's been readily available to the public in the past.
That's correct, but there will be the statutory form of financial power of attorney will be now available after July 1 through the Bar Association website.
Great. Does 231F now need to be included in DAA training?
Yes, 231F will need to be included in the dependent adult abuse trainings. I know that the Department on Aging does have a dependent adult abuse training, and if that has not already been updated, it will be very soon. So the answer to that question is yes.
I'm going to drop down here a moment, and then we'll go to Margaret. Will all nursing home residents be considered vulnerable regardless of their situation just based on the fact that they are in the care center?
We discussed this a little bit. This is Chantel again in my presentation, but there is a dependent adult abuse chapter. The DIA chapter covers residents of facilities. So Senate File 2239, I think I mentioned, specifically excludes employees of the facilities because
the DIA chapter already covers those residents, so they wouldn't fall under the new 235F. They are, by virtue of their residence in a facility, considered to be dependent adults for the purpose of the DIA Dependent Adult Abuse chapter.
Okay, great. Margaret, the next few are for you. Am I correct that any gift of monetary value would be taxed to the receiver of the gift?
No. The recipient of a gift is not subject to income tax. And then there are specific rules with respect to gift taxes. And the gift needs to be more than $14,000 to be treated as a taxable gift for gift tax purposes. But even then, everyone has a little more than a $5 million lifetime limit on gifts that need to be reported. So if there are gifts of more than $14,000 to a person in a year, a gift tax return must be filed. But generally, the giver of the gift pays that gift taxes. And again, until there's been $5 million or more of gifts made by the donor, there's no tax.
Okay, great. And another one. Who decides when a POA goes into effect?
It has to be listed in the power of attorney. If the power of attorney doesn't say anything, then it becomes effective. It's effective immediately. If it says it's effective upon my incapacity, then generally that would become effective upon receipt of a doctor's statement that incapacity has occurred.
All right. Where would copies of the new POA form be available?
It will be available on the Bar Association website hopefully soon after July 1. I know the Forms Committee is working on that right now. And also you can just download it it will be uploaded to these materials, what I just showed, so you can use that too.
Excellent. Thank you, Margaret. Will slides from presentations in this webinar be available to print out? Yes, the recorded presentation along with the PowerPoints, and as Margaret just indicated, the forms will be available on the department website hopefully by July 7th. Do we have any additional questions?
Thank you very much. I believe that concludes the webinar, and as Danica indicated, please look for these materials on the Department on Aging website. Thank you so much for attending.
Thank you.